In this video, we'd like to talk about a land use case that recently went before a Kitsap County hearing examiner. It involved the issue of whether maintenance of a gravel road requires a permit. The situation arose at the Kitsap Rifle and Revolver Club, and before beginning, we'd like to say that the club has been involved in a very long-running and well-publicized dispute with the county, a dispute that involves a number of different issues. And in this video, we're not trying to make a general comment on that dispute. The Kitsap Alliance of Property Owners is concerned with issues that might apply to any property owner in the county, issues that have to do with whether land use ordinances are reasonable and are enforced in a fair way. If you live in the county, these are issues that should concern you, regardless of how you stand on other aspects of the gun club situation. The case arose when the Kitsap Rifle and Revolver Club began adding gravel to an existing road on their property, a road that intersected with a county road. This is a picture of part of the road, and as you can see, it could use a little work. The county said the club needed a permit for the work because in adding new gravel, they'd widened the road, and the county issued a stop work order. The club said it hadn't widened the road, that it was merely performing normal maintenance. And eventually the case went to a hearing examiner. A front page story about the decision appeared in the Kitsap Sun on June 10th. The examiner ruled that the county had not shown that KRRC had widened the road. Since widening the road was the supposed violation of code, KRRC won the case, right? Actually, no. The examiner said it didn't matter if KRRC had widened the road because merely adding gravel during maintenance constituted an alteration of the road and therefore required a permit. Is this a logical ruling? If you read the comments about the ruling posted on the Sun blog, you'll see that the overwhelming majority of people say the decision is clearly wrong. Many feel that the examiner was bending the logic of the code in order to side with the county. People who commented ask, for example, if anything you do during normal maintenance is an alteration, do you need a permit to fill a pothole in a road or to pull weeds? In fact, the ruling is so odd that even the county said it wouldn't enforce it in all cases. The situation highlights important issues. And by the way, this isn't just the Kitsap Alliance of Property Owners talking. All of these issues were brought up by citizens who posted comments to the Sun blog. For example, can the hearing examiner, who is hired by the county, really be considered as unbiased? Or, in dealing with the examiner, is a property owner guilty unless proven innocent? Indeed, in the case of the gun club, the club was apparently guilty even after it was proven innocent. Then there's the issue of selective enforcement. The county says it will only apply this regulation in cases it chooses, and many people who posted to the blog clearly felt this alleged violation would not have been a problem if it had happened at another property. That's just not the way government should work, because it suggests the county might use land use codes selectively in order to pressure citizens on completely unrelated issues. Finally, one writer made the excellent point that if you need a permit to do even trivial things on your property, this is really just a new form of taxation because permits cost money. And these issues may become even more important soon. The county has proposed major changes in how land use codes are enforced. The proposal, known as Title V, moves code enforcement from the current system of civil law into one of administrative law, a situation in which county powers are expanded. The proposal is still under review. It has not been adopted by the commissioners, so it's not possible to know exactly what its final form will be, or even if it will be adopted at all. But property owners find many features of the Title V draft to be frightening. For example, low-level DCD staff members will be empowered to write citations that can have harsh punishments, fines of up to $1,000 a day. Also, county staff members may be able to enter property without the owner's permission and without a warrant. And in the proposed system, a property owner who appeals a code enforcement citation must bring that appeal to a hearing examiner. Of course, that raises the question of bias, which we've been discussing. It's also important to point out that in addition to the time involved in filling out forms and providing evidence, bringing a case before a hearing examiner costs the property owner a lot of money, a minimum of $500, and sometimes considerably more. because of fees added by the county for processing. So in conclusion, we'd like to say that as of early July, the hearing examiner's decision and the draft of Title V are still under review. Also, we want to repeat that the issues we've been discussing are specific to land use regulation. We're not trying to comment on the general situation of the gun club. The things we've been talking about, illogical and biased interpretation of land use codes, selective enforcement of the law, and ever-increasing fees for use of private property, are things that should concern all county citizens. These issues are central in the current discussion of Title V, our proposed new way of enforcing land use provisions. So if you're concerned about these issues, this would be a very good time to express that concern to your county officials.